Drawing conclusions after such a fruitful morning is really not an easy task. What we can say is that we've all learned a lot. There have been really valuable insights into the implementation of the effectiveness of this legal instrument. We know that it actually increased the efficiency compared to what existed before. It does not avoid problems. It has created a lot of problems, but at the same time, it has solved so many more problems that what is remaining is something that we can overcome with no problems. It's just not yet the moment where we've overcome them. So that means that even after 8 years of this succession regulation being in force, we are not yet at that stage that we can say it really, really works. It works well, yes, but there are some problems, and we've been working on finding out what these problems are. At the same time, we can say in all member states, as we've heard them today, there is a very constructive spirit towards the regulation. Everyone wants it to work. And this is the basis from which we can start. So what we can see is the European Court of Justice does its work to give us certainty. At least Perscha has certainly contributed to give us this feeling that there is a lot of certainty. Maybe my presentation has contributed to another feeling that you might have had, but you were certainly aware of these problems of how do national certificates and European certificates play or interplay. That is actually a topic that will also need to be dealt with when we think about reforming this regulation. With regard to this relationship between European certificates and national certificates, I was talking today also with some of your colleagues, and I was suggesting maybe it would be the best solution to have just, under the regulation, just one rule. So the rule would be the European Certificate of Succession travels, circulates, while the national certificates, they may travel, but the member states decide whether they want to accept them or not and which effects they attribute to them or not. Actually, this is also the case now because we do not necessarily know what it means when the regulation says a decision is recognized. What does this mean with regard to a certificate? Is it just the procedural effects? Is it also the material effects? That is not clear at all. So who will decide? Maybe in the end, the European Court of Justice decides, but is that really necessary? If we have a European certificate of succession for circulation, why do we not prefer that and allow the states to keep their national certificates, which can apply in the single country and can also travel if the other member states allow it? But do we really need to have rules on this in the regulation? I seriously doubt. And if we wouldn't try to qualify them as instruments or as decisions, we might get away with a lot of problems that we have now. So this is only a point to think about. It's just a suggestion, and maybe this is something that we can develop on another occasion. With regard to registration, what have we seen? We have seen that many member states have these problems that they see the European certificate and it does not contain enough information. So Hungary, for example, France, for example, Italy, for example, the Czech Republic, for example, they all tried to overcome this problem by just saying, well, we accept the European Certificate of Succession, but we add to it what we need for registration, and that's what we do on our own. We do not require this to be issued by the other state that issues or authority that issues the European Certificate of Succession. We do it on our own, but because we know best what our registration needs. So we implement these European certificate with all the additional information that is required. And I think this is very constructive it is the way to go because it allows us, and it allows actually the heir to have the least problems. He will just go to that country where the register is. The register will tell this person what she needs beyond the European certificate, and that will be it. That it is allowed for the member state to require additional information is now confirmed by the European Court of Justice. So there is no question whether this is in conformity or not with the European Certificate of Succession. So we see a lot of states actually doing a really constructive work on that. With regard to registers, the talk now has shown us that we can really, really benefit from such an interconnected register. And the point Alice made, and also came from Hungary, I think is a very important one. Because we want to avoid that conflicting decisions come up. And how can we avoid that? Not when we only register decisions, because that's too late. We need it much earlier, at a point where the proceeding is initiated. So every notary should be able to just check online if he or she is presented with a cross-border succession, if there is any notary, any court in any member state already working on this case. If there is, we know what there is to do. But now we can just rely on the information that we receive from clients. And whether this information is complete or not, we can seriously doubt that. Because as I've heard, for example, many Croatian citizens want actually that they get their own certificate in Croatia and have another certificate in the state of the habitual residence that may be for tax purposes. That is only a suggestion. But it may also be the case because it's easier in Croatia to work with a national certificate, and they would not get it because the court commissioner issues it if they would say, yeah, there is already something going on in another state. So this would be avoided. These parallel proceedings that Professor Rotelet was talking about are reality. And a register that is interconnected would really help us to avoid this. Yes. So what we can say is at this point, we maybe have more questions than solutions, but these are some insights that can help us take more steps in advance and forward. So thank you, everybody who has worked with us for this result. It has been a great pleasure for me, for Alice, who will close this seminar. And thank you again, Stefan Matik, for the organization of this wonderful event.
Thank you from my side, master of all questions. Thank you so much. First of all, I have a technical issue. Would you be so kind to fill in the evaluation forms that should be available in the room? I don't know if they're available online. I think so. I don't know. Well, closing words. First of all, I want to thank all the speakers, the panelists, the participants, and of course, not only Stefan Matik, but the interpreters who did a really great job. Thank you. Thank you so much. I've already said today that one of the main objectives of the succession regulation is to simplify life of heirs. We were gathered here and online to help to realize this aim, but also to simplify our lives as practitioners and to learn. I'm convinced that we all will do our best in the future, as we already did, to help to eliminate all obstacles, not only in the free movement of EU citizens, but also in the free movement of the European Succession Certificate, with or without add-ons. So you have earned your afternoon, and the sun is still shining. So let's just awake all together the Sleeping Beauty called ECS with our notarial kiss. Thank you so much.